You're welcome to Defenses to Criminal Liability Part 2. In Defenses to Criminal Liability Part 1, we looked at the general principles governing the governing justification and excuse as a foundation for many of the defenses to criminal liability that are provided in the criminal law. We looked at the nature of justification, and we looked at the various types of justification. And we noted that one important feature of justificatory defenses is that there is a trigger, and that trigger, which is usually a threatened harm, justifies a proportionate response from the person against whom the harm is threatened in relation to the plea of self-defense. We also looked at various other types of justification-based defenses, lesser evil based justification, and various other types. After that, we looked at excusatory defenses, and we noted that a basic feature of excusatory defenses is that there is a disability which causes an existing condition in the offender, and that condition is such as to make the offender not to be fully in control of his action, not to make his actions to be free and voluntary. And because his actions are not free and voluntary, then the law deems it fit to excuse him, to free him from criminal liability, because that criminal condition that crime was brought about because he was suffering from a disability arising from an existing condition. And then we also looked at various types of defenses that may come in under excusatory defenses. And after we looked at general principles governing justification and excusatory defenses, we now begin to look at specific defenses. We looked at public authority defense, where a person is acting in the execution of a law. We gave the example of law enforcement officers who are acting in the execution of the law. And by virtue of that, whatever they do in the process of executing the law, they are protected. Then we also looked at the case of judicial officers who are granted immunity from civil and criminal liabilities for anything done in the course of their duties. And so basically, that was what we looked at in Defenses to Criminal Liability Part 1. Now, we want to go further by having a presentation on Defenses to Criminal Liability Part 2. We'll share the slides in a minute, and then we'll begin the presentation. Once again, my name is Akeem Olajide Bello. I'm a lecturer in the Department of Public Law, Faculty of Law, University of Lagos. So today we'll be looking at the plea of self-defense, which is one defense that is predicated on the grounds of justification. We'll start by posing the problem. What is the problem involved in applying a plea of self-defense? And after that, we look at general principles governing the application of the plea of self-defense. And after the general principles, then we'll look at conditions for a successful reliance on self-defense. We'll look at conditions relating to the attack, and we'll look at conditions relating to the defense. What is the learning objective for this lesson? At the end of this lesson, students should understand the general principles governing the plea of self-defense and the rules governing the application of self-defense. And the lesson outcome, at the end of the lesson, students should be able to explain the general principles governing the plea of self-defense and explain and apply the rules governing the plea of self-defense, so that in the examination, if you are confronted with a problem question which raises the plea of self-defense, we want you to be able to explain and apply the rules governing the plea, both rules, derived from statutory provisions and judicial authorities, and then apply the rules to the problem question and profile a solution. Now, posing the problem. The problem involved in the application of the plea of self-defense in a charge of assault or murder is basically two. Now, the first is the problem of determining what harm or force is reasonably necessary to entitle the claimant to use force in return to defend self. So the first problem, or the first question when we are trying to deal with the issue of self-defense, is to ask the question, what is the nature of the harm or force that is necessary in order to entitle the claimant to use force in return? It is not every type of harm or force that is reasonably necessary to entitle a claimant to use force in return. So we want to look at what type of harm, what is the type of harm, the nature of the harm, or the force that is necessary. That's in the first condition. In the second condition, this relates to the problem of determining whether the force used by the claimant to protect self from the assault is such as is necessary for the defense. In the second question, we are concerned with the issue of the degree of the force that is used by the claimant to protect self from the assault or force. So what is the quantum of degree that the law allows to be used to repel the assault or the attack or the threatened harm? These are the issues that we'll be looking at, and we'll see how the statutory provisions and judicial authorities have explained the application of the relevant rules. The general principles. Now, I want to look at general principles that govern self-defense generally. There are principles that govern self-defense generally. We want to look at them. Now, the right to self-defense exists under Nigerian criminal law to defend, number one, self. It exists to defend others, and it exists to defend property. So the scope of the defense is wide. It covers self-protection, the need to defend self. It covers the need to defend others, where you are in a position to be able to help another person to defend himself or to protect himself from threatened harm or an assailant. And also, the right of self-defense exists in relation to defend property. There's a general right of self-defense which justifies any act reasonably necessary in order to resist actual violence threatened to the claimant or to another person, provided that it does not extend to an offense punishable with death. So this is a general right of self-defense, okay? This will justify any act reasonably necessary in order to resist actual violence threatened to the claimant or to another person, provided that it does not extend to an offense punishable with death. So this is the very low level, the very first level of the right to self-defense. You know, somebody has attacked you or threatened violence against you. The law allows you to resist it, okay? To use such violence that is necessary to resist it, provided that it does not extend to an offense punishable with death or involving grievous harm. Now, this will ordinarily cover a situation in which maybe somebody assaults you, maybe by slapping your face or pushing you, okay? Now, the law allows you to resist that actual violence threatened to your person, provided that the force you are using will not result in an offense punishable with death or grievous bodily harm. In other words, your reaction must not be such as to result in the death of the assailant or to cause the assailant grievous bodily harm. Now, if somebody takes a ruler and knocks you on the head, a little push can be a commensurate response, but it is certainly not a commensurate response if you take, a plank and hit his head, breaking his head and inflicting grievous bodily harm. So this is a very first low level of the exercise of the right of self-defense. There is also a second category of right to self-defense of the body, which justifies the causing of death. This is the second level, and this is the most serious level. Okay, here, the law allows you to exercise your right to self-defense, even if it results in causing the death of the assailant. Now, you can find this in Section 65 of the Penal Code and Section 286 of the Criminal Code. Section 65 covers an attack which causes reasonable apprehension of death or grievous hurt. 2, rape or assault with the intention of gratifying unnatural lust or abduction or kidnapping. So if somebody tries to attack you and it creates in you, and that attack creates in you a reasonable apprehension of death or grievous harm. In other words, the attack on your person makes you to fear on reasonable grounds, not on an unreasonable ground, on reasonable grounds, that, look, this guy is going to kill me, or this guy is going to grievously hurt me. Now, that apprehension gives you a right to defend your body. And the law allows you, even in defense of your body in that circumstance, to kill the victim if that results from your exercising your right of self-defense. Or if you are a woman or a girl and somebody wants to rape you, wants to commit the offense of unlawful sexual intercourse with you without your consent, then the law allows you to use such force as may cause death. Okay, rape or assault with the intention of gratifying unnatural lust. Or it could be rape, or maybe he wants to sodomize you. Or abduction, somebody wants to abduct you, wants to kidnap you. Then the law allows you to defend yourself, even if while you are defending yourself, it causes death. Now, also Section 286 of the Criminal Code. This provision governs unprovoked assault. Okay? If you look at the first paragraph, it talks about the fact that if somebody assaults you, then you are entitled to use such force as is necessary to defend yourself. Okay? But if the level of the assault is such as to make you believe on reasonable ground that your life is going to be threatened, or the assailant is going to cause you grievous bodily harm, and there's no other way for you to preserve yourself from death or grievous bodily harm, the law in Section 286 of the Criminal Code justifies causing death or grievous harm if the nature of the assault is such as to cause reasonable apprehension of death or grievous harm, and you believe on reasonable grounds that there's no other way for you to self-preserve yourself. Okay, if somebody takes out a cutlass and tries to, to cut you on the head, and in order to protect yourself, you raise up an arm, to shield your head, and the machete lands on your hand, and the assailant is still pursuing you, trying to cut you on the head again. So in that kind of a situation, that attack has caused you to reasonably apprehend death or grievous harm. And in that kind of a situation, the law allows you to use such force as may cause his death. And that will be a justified killing in that circumstance, and a plea of self-defense will avail you. Now, for the application of Section 286, read the case of Karimu against the state. Now, Section 287 of the Criminal Code relates to defense against provoked assault and the limitation of the defense. Now, if you read Section 287, this is the way it operates. Section 286 deals with unprovoked assault. You are not the one that created the scenario justifying the person attacking you before your right to self-defense arises. That's Section 286. Now, in Section 287, it relates to self-defense against provoked assault. Now, if you are the one that provoked another person to assault you, and that person now assaults you in a manner as to create in you an apprehension of death or grievous harm, the law now allows you to use such force as will counter his level of force or violence, even if it causes death. Now, I will explain that again. You are the one that provoked the assault. Let me give an example. You throw cold water on somebody. That's an assault. Okay? And he was provoked and he assaulted you. Ordinarily, a proportionate reaction to that may be a slap or a push or some other forms of physical outburst. But if in reacting to your pouring cold water on him, it brings out a machete and it starts running after you. He cuts you with the machete the first time. You got up, you started running away again. It continues pursuing you. Now it's clear that this guy now wants to kill you. That has created a reasonable apprehension of death or grievous bodily harm. Although you are the one that provoked the initial assault, the law now allows you to use such force to overpower his own reaction, which has created a reasonable apprehension of death or grievous bodily harm in you, now necessitating you to take steps to protect yourself from death or grievous bodily harm. So if you now kill him in that situation, the plea of self-defense will avail you, although you are the one that started by provoking the assault. But the limitation on the defense is that your initial assault, when you provoke him to assault you, you are the one that provoked the assault. If your initial assault was such as to make him to want to, if your initial assault was such as to create in the offender a reasonable apprehension of death or grievous bodily harm, that now made him to attack you with a commensurate force, which now creates a reasonable apprehension of death or grievous harm in your person, that defense will not apply. Section 287 will not apply because when you started the initial, when you provoked the initial assault, you went about it in a manner as to cause reasonable apprehension of death. Now, I want this point to be clearer because I usually take some time to explain this so that students will be able to understand the point very well. So just give me a minute. I want to project my, I want to read from the provisions. I want to read from the provisions of the criminal code, the specific wording, so that you'll be able to see clearly how that provision applies. So just give me a couple of minutes. Let me read out. I'm trying to open my system to section 287 so that you will see how the provision is worded. Section 287. Okay, the title is Self-Defense Against Provoked Assault. Now, let me read out the provision. It says, when a person has unlawfully assaulted another or has provoked an assault from another, and that other assaults him with such violence as to cause reasonable apprehension of death or grievous harm, and to induce him to believe on reasonable ground that it is necessary for his preservation from death or grievous harm to use force in self-defense, is not criminally responsible for any such force as is reasonably necessary for such preservation, although such force may cause death or grievous harm. Okay, let me see if I can project that. Yes, I can project it. Okay, so you can see the provision now. That first paragraph governs the scenario that I explained to you in my analogy. You throw cold water on your friend, and your friend, you are provoked an assault. Okay, you are the one that unlawfully assaulted him by throwing cold water at him. So, and you are provoked him to now want to assault you. But instead of assaulting you by maybe a push or a slap, it now brings out a cutlass and start chasing you. Now, under the first paragraph, that creates a reasonable apprehension of death or grievous harm in your person. I was only playing with you. I only poured cold water on you. Now you want to kill me. Now the law now allows you to preserve yourself, okay, and to use such force as is necessary to preserve yourself, even if death results. That is the first paragraph. Now the second paragraph now contains a limitation, and I explained it earlier. It says, this protection does not extend to a case in which the person using force, which causes death, that refers to you now, or grievous harm, first began the assault with intent to kill or to do grievous harm to some person, nor to a case in which the person using force which causes death or grievous harm endeavored to kill or to do grievous harm to some person before the necessity for so preserving himself arose, nor in either case, unless before such necessity arose, the person using such force declined further conflict and quitted it or retreated from it as far as was practicable. Now again, let me explain that. The first paragraph will not protect you. If when you provoke the assault, your intention was to kill or to do grievous harm. For instance, instead of the cold water that you poured on your friend, if what you intended to do was to cut him with a machete, and you start running after him, trying to cut him with a machete, and you hit him the first time, you cut him in the hand, and he fell down, he got up, you still continue to pursue him. Now that guy is now apprehending death, because from the way you are chasing him, it appears that your intention is to kill him. That now gives him a right to try to defend himself from death. Now, if in the course of trying to defend himself from death, you now kill him, you cannot rely on this provision. That's what the second paragraph is saying. Because when you started the attack, your initial intention was to kill or do grievous bodily harm. It was only when the guy now tried to defend himself, saying that you wanted to kill him, that your life is now being threatened. And because your life is now being threatened, the law will not allow you to rely on the plea of self-defense, because you are the one that initiated the initial attack on your person, which you are the one that created the scenario that made the guy feel that you wanted to kill him, thereby justifying him in wanting to preserve his life. And you now feel that now that he wants to preserve his life by killing you, you now want to resort to your right to self-defense. The law will not allow you to do so. So that is the way Section 287 of the Criminal Code operates. Okay, so let's go back to our slide. So I've explained the provision of Section 287 there. And you can see how that provision is illustrated and explained, as I've explained, in the case of Famakiwa against the state, 2016 11 Nigerian Law Report, Part 1524, at page 538. Now, the right to self-defense exists in Nigeria with respect to others. In other words, you have a right to defend yourself. The law also allows you to exercise a right of self-defense with respect to others. Maybe somebody who is not in a position to defend themselves. You can see section 288 of the Criminal Code and section 80 of the Penal Code. The same requirements which apply to defense of self also applies with respect to the defense of another. There is also a right to defend property and the property of another. You know, initially when I started, I said the scope of the right to self-defense extend to self-defense of self and self-defense of others and self-defense of property. So there's also a right to defend property and the property of another, whether movable or immovable. You can see section 60 of the Penal Code and sections 282 and sections 289 to 294 of the Criminal Code. Under the Criminal Code, the degree of force that may be used to defend property varies depending on the nature of the property. Where the property is a dwelling house, the claimant can use such force as he believes on reasonable grounds to be necessary in order to prevent the forcible breaking and entering of the dwelling house, either by night or an attempt to break in and enter with intent to commit a felony. So if the property you are defending is a dwelling house, the law allows you to use such force as you believe on reasonable grounds to be necessary in order to prevent somebody from breaking into your house or from entering your house in order to commit a felony. In R&AB, the defendant, a crowd gathered and they were trying to set his house ablaze. The man shot into the air to scare the crowd away, but they persisted in their endeavor to, set the house ablaze, and the man shot into the crowd, and the court held that he had a right to defend his property, and the death in those circumstances were justified. Under the Penal Code, the exercise of the right of private defense justifies causing death when the act repelled is any of the following. Under the Penal Code, the right of private defense justifies causing death when the act repelled is any of the following. Robbery. Here, the provision actually, let me just share the provision so that we can see it very well. Just a minute. Section 66. Section 66 of the Penal Code. I'll be there in a minute. I want you to see something in that provision. Now, Section 66 says the right of private defense of property extends under the restriction mentioned in Section 62 and 63 of the Penal Code to the voluntary causing of death. Okay, so that provision relates to a right of private defense of property. It relates to a right of private defense of property. Just a minute, yes. So Under the Penal Code, the exercise of the right of private defense justifies causing death when the act repelled is any of the following: robbery. So if you are in your property and an armed robber is trying to break in, then the law empowers you to use such force, even if it causes such force, even if the force causes death. House breaking by night. Somebody is trying to break into your house by night. Mischief by fire committed on any building, tent, or vessel. Which building, tent, or vessel is used as human dwelling or as a place for the custody of property. Or theft, mischief, or house trespass in such circumstances as may reasonably cause apprehension that if such right of property defense is not exercised, death or grievous hurt will be the consequence. So these are the circumstances in which the Penal Code allows you to use a right of private defense of property to cause death. When a robber is trying to break into your house, house breaking by night, mischief by fire, and the other circumstances provided there. The exercise of the right of defense of other types of property, movable or immovable, is subject to the qualification that it does not do harm to the person against whom the right is exercised. So if you are defending other types of movable or immovable property, apart from the ones that we have examined, then there is a limitation. The law does not allow you to use, it is subject to the qualification that it does not do harm to the person against whom the right is exercised. So you can defend movable property without doing harm, and you can see that in sections 289 and 294 of the Criminal Code. Although Professor Okonkwo and Nash, the learned authors Okonkwo and Nash, argues that ideally the provision should have been that no grievous harm should be caused, because how do you defend your movable property from somebody who wants to hold on to possession and does not want to yield possession voluntarily without doing him some harm? So they are of the view that the provision should have actually read should not do grievous harm, rather than just say not to do harm. You can see the case of Nwuzoke versus the state, 1988, 1 NWLR, part 72 at page 529. Now, similarly, the right of private defense with respect to property, other than those specified above under the Penal Code, does not extend to the inflicting of more harm than is necessary for the purpose of the defense. Now, you can see here that the provision of the Penal Code here is more realistic, because it says that the right of private defense with respect to property, other than the ones we have examined earlier, does not extend to the inflicting of more harm than is necessary for the purpose. Unlike the provisions on the code that says you must not do any harm at all. This says you must not do such harm than is necessary. So if it is minimal harm or a harm that does not amount to grievous harm, that may be justified under the provisions of section 62 of the Penal Code. Where defendant successfully raises a plea of self-defense in a murder charge, the proper verdict is not guilty, because self-defense affords a complete defense to a murder charge. So a defendant who successfully makes a plea of self-defense is entitled to a verdict of not guilty. You can see the case of Unwude versus the state, 1985, 3 NWLR, part 10, page 444. And the defendant will be discharged and acquitted. See the case of Karimu against the state, 1996, 7 NWLR, part 462 at page 579. Now, we have looked at the general principles relating to self-defense generally. Now, we want to look at the specific conditions that govern self-defense pleas. And the first condition is a condition relating to the attack. There are two conditions governing the successful plea of self-defense. The first is a condition relating to the attack. The nature of the assault that will sustain a plea of self-defense must be such as will cause reasonable apprehension of death or grievous harm. And the person using force by way of defense believes on reasonable grounds that he cannot preserve himself without resort to lethal force in defense. So when we are talking about self-defense in a various in the serious charge of murder, for instance, the nature of the assault that will sustain such a plea of self-defense must be the kind of assault that will cause reasonable apprehension of death or grievous harm. It is not just any kind of harm that will sustain a plea of self-defense for a murder charge. It must be such harm as will cause reasonable apprehension of death or grievous harm. And the person using force by way of defense believes on reasonable grounds that he cannot preserve himself without resorting to lethal force in defense. In Lawful against the state, the Supreme Court held that an objective test is used to determine whether the claimant had reasonable apprehension of death and reasonable grounds to use force in defense. So the court will look at the circumstances. You cannot say because somebody slapped you and is threatening to slap you the second time, therefore, you apprehended that he's going to kill you, or you apprehended that he's going to cause you grievous harm. And because of that, you brought out a gun and you shoot him in the head. Now, the court will apply an objective test. What will a reasonable man do in the circumstances? Will a reasonable man respond to a slap with bringing out a gun and shooting the assailant in the head? That certainly cannot be the way a reasonable man will respond. And if the offender responded in a way a reasonable man would not have responded, then the defense will not avail it. Now, in Regina and Oyemazu, the court stated that, look, the plea of self-defense is not applicable to somebody who is unnecessarily excitable, somebody who suddenly apprehends danger when there is no danger, or apprehends death when the circumstances does not justify death. In other words, the court will apply an objective test of what a reasonable man in the circumstances will apprehend. Okay, if you look at the case of Lawful and the state, that was a case involving some undergraduates of the then University of Ife. You know, the three of them went into the town of Ile-Ife to visit a friend. And after they were returning to campus, so on their way to campus, a dispute arose, a quarrel arose between the appellant, Lawful, and the deceased. And the appellant made some comments about the deceased's girlfriend, and the deceased did not like the comment. And as a result of that, a fight broke out between the two of them. Now, as the fight broke out, the two of them had knives in their possession. The deceased brought out a knife and tried to stab the appellant. The appellant tried to avoid the stab. He fell and the deceased stabbed him on his leg. And immediately he tried to get up. The deceased rushed at him again, trying to stab him the second time. And this time, the blade of the knife just grazed his hand. And the deceased still tried to attack him the third time, at which time the appellant brought out his own knife and stabbed the deceased in the shoulder. According to him, his intention was to make him to drop the knife, and the fight continued, and the deceased died. So the Supreme Court in that case ruled that in the circumstances, the deceased, had reasonable, the appellant had reasonable ground to apprehend death because the deceased had attacked him once, stabbed him in the leg, tried to stab him again in the shoulder, and the blade of the knife just grazed it, and again came to him the third time, still trying to stab him, that is sufficient to create a reasonable apprehension of death in the appellant to entitle him to use force, which resulted in the death of the in the death of the deceased. And therefore, the court ruled that the plea of self-defense succeeded. Although that plea did not succeed in the court of first instance and in the court of appeal. So the court in that case, explained how that objective test will apply in case of self-defense in relation to the offense of murder. You can also see the case of Uwagboyi and the state, 2008 12 Nigerian Weekly Law Report, part 1102 at page 621, and Odu against the state, 2001 10 NWLR, part 722 at page 668. The second condition governing the application of the plea of self-defense to a murder charge is the conditions relating to the defense. Now, the second condition for the application of self-defense is that the force used by the claimant to protect self from the assault must be necessary for the defense. The force used must be necessary for the defense. Section 286 of the Criminal Code, and does not extend to the inflicting of more harm than is necessary for the defense. Section 62 of the Penal Code. Now, the second condition relates to the degree of force used by the claimant in responding to the attack on his person. While the second condition is clear from the statutory provision, it is often described variously. For instance, in Kim and the state, the Supreme Court stated that for the plea of self-defense under Section 62 of the Penal Code to succeed, the following must be shown. One, that the life or body or property of the accused was in imminent danger from an attack by the deceased. We can see that this first condition, stated by the Supreme Court in Kim and the state, relates to the first condition that we examined earlier, the condition relating to the attack. Okay. Then, that the accused used no more force than was necessary to repel the attack, that the force used was proportionate to the attack, and that the force used was reasonable in the circumstances. Now we can see that the first requirement relates to the condition of the attack, which we have discussed earlier, while the second to the fourth relates to the condition relating to the defense. In other words, it relates to the degree of force that was used by the claimant. The force the claimant must not use an amount of force than is necessary. The force must be proportionate and the force must be reasonable in the circumstances. You can also see the case of Ahmed against the state, 1999 7 NWLR, part 612 at page 614. That case was decided under the provisions of the Criminal Code. Now, in determining whether the condition relating to the defense has been fulfilled, the court will determine whether excessive force was used. The court will determine whether excessive force was used. In other words, the court will evaluate the degree of force that the claimant used in relation to the harm that was threatened or applied to his person. Now, in Lawyer against the state, I referred to that case earlier, the Supreme Court, par Augustine Inamani, GSC, at pages 843 to 844, said the following in relation to the issue of excessive force. And I've quoted it because it's important. His Lordship stated, it has been contended that as against the minor stab wounds the appellant received on his legs and shoulders. He dealt the deceased 5 serious stab wounds from which he died. Excessive wound has been described as force, which is more than a reasonable man would consider necessary. To my mind, the degree of force used is only relevant while one is considering the circumstances of the encounter, so as to determine whether there was reasonable grounds for the prisoner's belief that his life is in danger. Once it is agreed that there was such grounds, the amount of use by the prisoner to preserve his own life becomes immaterial. In a fight to the death, it is only to be expected that once the prisoner believes on reasonable ground that his life was in danger, he will go all out to preserve his life. And that may entail making sure that the deceased is dead beyond any question. Now, if you look at the fact of the case, I've already given you the facts of the case earlier. The deceased stabbed the appellant on his leg, tried to stab him on the shoulder, and the blade of the knife just grazed the shoulder. And then he tried to stab him again the third time. At which point, the appellant now began to stab the deceased, and he stabbed him 5 times. Now, the Supreme Court said that in trying to determine the amount of force used by the claimant, what is important is the amount of, is the degree of apprehension that was already created in the mind of the claimant that gave him reasonable grounds to believe that his life is in danger. So once he believes that his life is in danger and he needs to take steps to preserve his life, now that justifies using an amount of force that can cause death. And once that level is reached, then it does not even now, it does not matter any longer the amount of force that the claimant now used. And the court said, in this particular circumstance, from the nature of the attack on the appellant in Laoye's case, it was clear that the deceased is out to either kill Laoye or to inflict grievous bodily harm. And that created an apprehension in Laoye that, look, this guy wants to kill me. And that apprehension was reasonable, having regard to the amount of attempt the deceased made. He stabbed him on the leg, he stabbed him on his leg, he stabbed him on his shoulder, he still came against him, trying to stab him. The court held that at that point, it had become a fight to the death. And the amount of force used by the appellant to preserve his life is no longer immaterial, because this is a fight to the death. He can continue to stab him until he's sure that the man is dead, because the man has already manifested, the assailant has already manifested a clear intention to kill the claimant. So once that threshold is reached and it has triggered his reasonable apprehension of fear and the need for him to preserve his life, then the amount of force that he used is no longer material. He can continue to stab him until he is sure that he's dead. And that is very significant. The import of this decision in relation to the second condition, the issue of degree of force necessary for defense must be related to whether the assault on the defendant has created reasonable apprehension of death. Once the attack on the claimant or the defendant has created reasonable apprehension of death, then he can use whatever degree of force that is necessary to protect himself. Where it does, the defendant can use any amount of force to secure his life. This is significant because it shows that the determination of the second condition is intrinsically connected with the first. both the first condition, the condition relating to the attack, and the condition relating to the defense are closely connected together. Where the nature of the assault is not such as to create apprehension of death, then the use of lethal force will not be considered necessary and justifiable. Of course, we have stated that earlier. Where victim is exercising a lawful right of arrest, no question of self-defense will arise against the victim. Now, if a victim is exercising a lawful right of arrest, then you cannot say you are exercising a right of self-defense against the victim. And the case of Abdalabi versus Borno Native Authority clearly illustrates that. The deceased was sleeping in his house. The appellant broke into the house, and the deceased tried to grab him to arrest him. And the appellant now stabbed the deceased to death. And the court said, look, the deceased, it was the appellant that unlawfully broke into the deceased dwelling house. And the deceased had the right to arrest him. And the appellant cannot be allowed to now claim that he's exercising a right of self-defense against the victim who was exercising a lawful right of arrest of somebody who broke into his house. And that in any case, there was no apprehension of death because the deceased did not use any weapon, any offensive weapon, any dagger or any machete, or did not attack him in such a manner as to create a reasonable apprehension of death to justify him using a right of self-defense. So the court stated in that case that the plea of self-defense cannot succeed because where a victim is exercising a lawful right of arrest, no question of self-defense will arise against the victim. Where there is no reasonable apprehension of death, excessive force cannot be justified. Okay, you can see the case of Udo and the Queen, 14 Waka, page 352. Somebody broke into the appellant's house, and the appellant now started chasing it, and he caught up with him. And the thief who broke into his house was not armed. He was not using any force to resist arrest, but the appellant then attacked him and hacked him to death. And the court said that there was no apprehension of death on the part of the appellant, and the excessive force he used is not justified in the circumstances. So the plea of self-defense did not succeed because there was no apprehension of death. If the person who broke into his house had tried to attack him when he pursued him, and in order to defend himself against the attack, on apprehending death result, then he could have been able to rely on a plea of self-defense. Where the plea of self-defense fails on account of excessive use of force, the defendant will be convicted of murder under the criminal code. You know, we have said that the amount of force used must not be excessive. It must be commensurate with the harm that is threatened. So if excessive force is used, the defendant will not be entitled to rely on the plea of self-defense, and he will be convicted of murder under the provisions of the Section 298 of the Criminal Code. You can see the case of Regina and Oyemazu. I've referred to that case earlier. The position under Section 222, subsection 2 of the Penal Code, Section 222, subsection 2 of the Penal Code, is that the defendant using excessive force in private defense will be liable for culpable homicide not punishable with death. So In comparison with the position under the criminal code, if you kill somebody and you raise a plea of self-defense and your plea fails because you use excessive force in defending yourself, then you will be convicted of the offense of murder. But under the penal code, if the plea of private defense fails, the offender will not be convicted of murder under the penal code, which is the offense of culpable homicide punishable with death. The offense of murder under the penal code is culpable homicide punishable with death, while the offense of manslaughter under the penal code is culpable homicide not punishable with death. So the difference between the position under the criminal code and under the penal code is that under the penal code, if a person relying on the plea of private defense is not able to successfully establish that claim because of use of excessive force, then he will be convicted of culpable homicide not punishable with death, which is the equivalent of the offense of manslaughter under the criminal code. Now, I think the position of the law under the penal code is fair because in the first place, the offender did not go about setting out to kill the victim, in which case his offense would clearly have been the offense of murder or the offense of culpable homicide punishable with death. It was as a result of the threat of harm created by the conduct of the victim that necessitated the claimant resorting to the claim to the right of self-defense, although in exercising that claim, he used excessive force, which disentitles him to rely on that defense. But because he did not set about initially, he did not, it was not a case of premeditated murder. He only acted in self-defense when he apprehended harm, although he used excessive force in defending himself. It is only fair if the offense is reduced from murder to manslaughter under the criminal code, or from culpable homicide punishable with death under the penal code to culpable homicide not punishable with death as we have it in the penal code. So the provisions of the penal code is fairer to the person who failed to successfully establish a plea of self-defense because of the use of excessive force. And the provisions of section 208 subsection 2 of the Criminal Law of Edo State 2022 has now adopted the provision under similar to section 222 sub 2 of the Penal Code to impose liability for manslaughter where death results from excessive use of force in self-defense. Okay, so we have been looking at the plea of self-defense in relation to the offense of assault and the plea of self-defense in relation to the offense of murder. And we started by looking at general principles that governs self-defense generally. And we started by looking at the scope of self-defense, that it extends to defense of self, extends to defense of others, it extends to defense of property movable or immovable, but the degree of force allowed with respect to ordinary assault is not the same degree of force allowed to defend self where the harm is of such as to create a reasonable apprehension of death or grievous bodily harm. And we looked at the various provisions under the penal code and under the criminal code that governs self-defense under the criminal code, and the defense Christine under the penal code as private defense of the body or private defense of the property. And we looked at those general principles before we now looked at the principles that specifically relates to self-defense with respect to the offense of murder. So I expect that you will take time to carefully listen to this lecture, to this presentation, note your questions, note where you want more clarifications or more information to be provided, so that by the time we come to class, we'll be able to go over all the critical aspects, and then we'll be able to respond to all your questions and all your inquiries. Please remember to click the subscribe button at the end of this viewing, so that whenever I upload subsequent presentations, you will receive the alert and you'll be able to have access to it. So thank you very much. God bless.